SJC-11447, Commonwealth versus Lees.
Find the right seat.
Ms. Billowitz, good morning.
Good morning. May it please the court, Elizabeth Billowitz for defendant appellant Brian Lees. This first-degree murder case presents an unusually straightforward ground for a new trial. Here, a potential juror answered yes to a voir dire question about whether graphic photos of the victim's dismembered body would affect his impartiality. He was sworn in over objection, the photos were entered into evidence, and he deliberated to verdict, violating Mr. Lee's federal
But
and
it wasn't
state
that
rights to
simple,
impartiality.
right?
I'm sorry?
It wasn't that simple, obviously. Nobody thought it was unusual that he said yes at the time. It seemed like everybody thought he was just answering, yes, I understand what the question is.
Well, I would respectfully disagree with that, Your Honor. First of all, a plain reading of the question and the answer indicates actual bias. He's asked, in the trial, you will see some graphic photos of body parts. The question is whether you think that would affect your ability to be a fair and impartial juror. The juror says yes. This same exchange happens repeatedly throughout 3 days of the jury selection, and at other times, when that precise question is posed and a juror responds yes, the judge excuses the juror.
When you say the same response over 3 days, was it the same juror for 3 days, or were they different jurors each time?
Different jurors were, so in this particular juror, number 226, that was effectively the end of the exchange about the photos. It seems that everyone misheard it, moved on, and for a short period of time, Mr. Lees represented that he was content. However, the issue of bias around the photos came up again and again and again, and in total, 11 jurors were excused sua sponte because of their responses. Sometimes they just said a blanket yes or no, depending on how the judge constructed the question. Sometimes he asked it where impartiality would require a yes answer. Sometimes he rephrased it so it would require a no answer. But the point is, on 11 occasions, when a juror said that he or she would have some problem with the photos, they were excused. And sometimes they were excused even when they indicated some sort of ambivalence about it. So I think it's fair to infer, looking at the jury selection as a whole, that this issue was front and center, that the judge was very concerned about it, and quite simply that this was a mistake. And Mr. Lees became aware of this, it looks like only several minutes later, and tried to bring it to the judge's attention and said there was a misunderstanding. I'd like to challenge, he indicates he wants to challenge juror number 2, and says it was a misunderstanding.
But he didn't say, I want to challenge for cause.
Well, the judge really doesn't give him a chance to articulate whether this was a for-cause challenge or whether he was trying to exercise a peremptory. The court simply says, I declined to do that. Mr. Lee says it was a misunderstanding. The court said, I understand, your rights are saved. Either way, whether this was the denial of a peremptory, whether it was denial of a for-cause challenge, or even whether this was just a failure of the trial judge's responsibility to inquire further and root out bias, under any of those frameworks, this is abuse of discretion.
Okay, so if it's an abuse of discretion, put that in the context of how we would review that and what that would mean for your client.
The standard is abuse of discretion, and because this is structural error, there is no showing of prejudice required. And it is true that this is structural error, whether this is considered denial of a peremptory or denial of a for-cause challenge.
Now, the Supreme Court said recently in Weaver that kind of structural error, some kinds of structural error don't necessarily require prejudice. Is that right?
No, I think that was in the context of waiver.
Oh, in the context of waiver. All right.
That's right.
So,
And this
so
case
this
does
would
not-
not be, because you'd say this was preserved.
It is absolutely preserved. It's true that the objection was slightly delayed here, but it was still only minutes later. It was on the first day of a 3-day jury selection, and the primary purpose of the raise or waive rule is judicial economy and giving the trial judge an opportunity to address a problem when it comes up. And here, certainly, the judge had ample opportunity to hear Mr. Lees out and to redress this error and continue on with the jury selection. So this was preserved. The judge explicitly informed Mr. Lees, your rights are saved.
So we don't need to examine any issue of prejudice or anything like that?
Correct.
If it was error, it's structural error, it was preserved in your mind, and there's no, end of story.
Exactly.
New trial, is that the result?
New trial. That's exactly right. This court has been clear that the presence of even one juror who is impartial violates a defendant's right to trial by an impartial jury. And it is indeed a simple and straightforward matter, abuse of discretion and structural error, and a new trial.
Why doesn't it matter if it was a peremptory or a for cause challenge that the defendant was making?
Because the essence of the challenge was juror bias, and the standard of review is the same.
It's not clear, though, is it, that the judge knows that that's the essence of the challenge?
He says that it's a misunderstanding. The
Right.
judge says, "I understand." So it's not necessarily explicit in that exchange, but because this issue has come up so many times, and in fact, it's interesting to note that even the Commonwealth raised at some point the adequacy of the judge's inquiry here and said, I think when these prospective jurors are coming in and indicating that they have a bias, that the court's not asking them what their bias is. I think it's depriving both the Commonwealth and the defendant of their rights. So the judge was, or at least should have been, very attuned to this issue as one of bias. And again, jurors were dropping like flies
Was that
because of their
before-
response to the bias question. And in any event, because the standard is abuse of discretion and because it's structural error, when this issue is preserved, there really isn't a different analysis. And I think it's a little bit of a red herring to get caught up in whether the defendant intended to make a for cause challenge or a peremptory challenge. Even if it was peremptory, because the jury hadn't yet been sworn, a peremptory still would have been timely.
Okay, so I'm going back over. Page 106 to 107 is when this occurred. Page 133 to 134 is when he objected. So there were 20 pages in between. And I do note that the judge, after Mr. Lee says, "I am content with this juror," the judge says, "You are content?" And Mr. Lee says, "Yes." So what do we do in a context in which the person answers the question, the individual chooses to represent himself, says he is content, the judge has said the procedure is that you do your strikes immediately after the individual voir dire, and then the judge later on says essentially, you knew the rules. The rule was that you had to basically express you had to strike either for cause or peremptories at the time, and you didn't.
Well, don't believe that the judge said that precisely. He said, we're not going backwards.
Did
but-
he earlier on, did he set the rules before they began? Usually, we would do that.
Yes, I believe he articulated the process, and I would agree, Your Honor, if I were coming here on a motion for new trial or an appeal where this issue was never raised during the jury selection, we would be in a different posture in terms of waiver. Here, where it was moments later, where there was absolutely no prejudice to anyone, really not even an inconvenience to the judge. This, again, they had just started the jury selection process, which went over 3 days. There is no reason to treat this any differently than if Mr. Lees had immediately brought this to the court's attention.
And you would agree also that there's no reason for us to treat it any differently than had he been chosen to be represented by counsel?
That's correct. I believe that, yes, I'm certainly not saying that he should be allowed extra leeway here because he was pro se. It appears that his standby counsel brought the error to his attention. At least one of those intermediate jurors in between juror number 226 and when Mr. Lees objected, this issue came up at least once, and you could infer that that's what got standby counsel's attention focused on this issue.
Then on page 134, after Mr. Lee says, Your Honor, I didn't understand juror then, and I would like to challenge juror number 2, if that's possible, if you'd let me do this one time. The judge says, no, I decline to do that. And then he goes on to say, it was a misunderstanding.
Yes.
What are we to understand of that last sentence?
I believe that Mr. Lees was correct in that everybody misunderstood the juror at the time. That one-word answer, for some reason, nobody caught it. It was a misunderstanding. And I think...
But you're assuming at that point in time that the judge knew exactly what had happened.
that he understood what Mr. Lees said when he said it was a misunderstanding?
No,
Or,
it wasn't Mr. Lees who says it was misunderstanding. It's the court. It's Judge Grassley.
no, actually, that was an error in the transcript. Both my brief and my sister's brief point out that it was an error, and the court reporter actually agreed that was the statement, it was a misunderstanding, is properly attributed to Mr. Lees.
Oh, I'm sorry. But he didn't say what it was a misunderstanding was about. Okay, so Mr. Lee says that.
Mr. Lee
Does
says it
that
was
mean that you have, do we have the tape recording of this part of it, so we can determine whether Justice Budd is correct with regard to
Who
what
said
the
it was
yes
a
meant, whether the
misunderstanding.
yes was a statement, yes, I can't be fair, or simply sort of a hum type of yes?
I'm not sure that the tone of voice would shed any light. It is a straightforward acknowledgement of actual bias, importantly, on an issue that was of central focus during this entire voir dire.
But you clearly have gone back to revise the transcript with regard to page 134. So I assume there is some
Yes,
ability to do that.
certainly, and if the court would like that, we can provide.
Okay, well, I'll hear from your sister with regard to that, but I do think if there is a tape recording of those portions so we can actually hear tone of voice as well as words, it may help us to understand what is going on a little bit more than the transcript would.
Although I would add, Your Honor, that even if the juror's tone of voice somehow indicates something other than what seems to appear on the page, that Mr. Lee still would have been entitled to use a peremptory.
Well, but let's explore that. So judge sets, again, assuming the judge did set the rules, it's arguably a different position if the judge never said, no, we're going to do all the strikes immediately after the voir dire of an individual juror. That is your opportunity to do it, and so this arguably is a procedural defect. He said, this is the procedure, we do it now, and if you don't do it then, you basically waive it. He says, I'm content. It's the first day of trial. He then, 5, 10, 15, 20 minutes later says, I'd like to go back. And the judge essentially says, I made a procedural rule, I'm going to stick with it. We're not going to basically have second thoughts, because that's the rule that I set. Can a judge not do that?
As long as the jury has not been sworn, that is the cutoff point for that. I mean, it is true that a judge, there is some discretion in terms of setting the rules of sequence and procedure. However, when juror bias is at issue, when there has not been, regardless of the inflection of this tone of voice, the judge certainly should have inquired further of this juror. So given the thin questioning on this bias issue in the first instance, coupled with Mr. Lee's saying moments later, indicating that he wants to strike this juror, even if he doesn't articulate whether it's peremptory or for cause, it was abuse of discretion for the court, at least at that point, not to inquire further, not to ask this juror further questions that would have revealed bias, especially given at this point these gruesome photos of dismembered body parts. Everyone has flagged this at this point as the issue that jurors are responding to, and that is resulting in many jurors being excused.
So what meaning do we give? We have a very experienced judge, asked the same questions, though I guess he changed the questions during the course of this is the first day of jury selection. Later on, when the answer was yes, he followed up with it, I gather. Or did he? I mean, if we read the entire voir dire, we hear people say, yes, I think it may. Do we have the judge follow up with further questions? Or?
Yes. In some cases, yes. There are at least 4 instances where a one-word answer by a juror to this question about photos gets the juror excused sua sponte. So the judge is doing it, he's doing it right there. And in other cases, if the juror is expressing any kind of ambivalence, in most of those jurors, the judge does drill down more. But even at the point that Mr. Lee said, hey, I want to go back and challenge juror number 2, even at that point, the Commonwealth has already raised this concern about the judge not questioning adequately about juror bias.
Not with regard to that particular juror, though, right?
Not with regard to that particular juror.
And is it your understanding, just based on the transcript, that the judge understood why the defendant wanted to, excuse this juror?
He says, I understand.
Right.
But he doesn't, he certainly doesn't give Mr. Lee's enough opportunity to explain
But is it your understanding that he understood that, he indicated, that the juror indicated bias and he was going to keep him on the jury anyway?
I'm not sure that is...
Because he followed up with questions in other cases, right?
That's right. I think that to the extent that he kind of cut Mr. Lee's off and didn't allow him to express the nature of the challenge and what the basis of the challenge was, that in and itself was abuse of discretion.
Now, counsel, since this is coming down to a question of how does yes sound, or what did the juror mean, what did the juror understand, and what did he say, don't you think this would have been better raised through a motion for new trial or to inquire of the juror himself?
I think that it is clear from the transcript what the words were. I would submit that there is no inflection, that the tone of voice would not change the meaning of this exchange, especially when you have the same exchange being repeated and the judge understanding it to be biased and excusing sua sponte the jurors who responded in exactly the same way.
But in this case, I'm so sorry, but in this case, the defendant didn't catch it, the prosecutor didn't catch it, and the judge didn't catch it.
Well, eventually, 15 minutes later, no more than, they did catch it, and that was, so.
But nobody, it wasn't clear what it was that was caught at the time, right?
I think that it is certainly inferable, given that the jurors in between the time when this one was accepted and when he raised objection, given that the photos as bias were being raised, and given that the Commonwealth said, the judge, Your Honor, you're not questioning these jurors to root out bias. I think if the judge's attention wasn't on it, it should have been. And so even if it wasn't in his mind, the failure to, at that point, address this issue was abuse of discretion.
Okay,
Thank you.
Not so fast. I'm struggling with this. Okay, let's go back to the good old days when I was a Superior Court judge, and let's assume that we're trying this case, and you're the defense lawyer, and a juror answers, "Can you be fair?" and the answer is no. So I turn to you, and you say you're content. And I ask, as the judge did here, you are content? And you say, yes. I essentially say, really? And you say, yes. Do I then have an obligation to remove the juror even though you have said you're content?
I would say yes. There's a constitutional obligation to remove a juror who expresses actual bias. And I would also say that there is a statutory duty upon Superior Court judges to fully examine jurors with respect to possible bias or prejudice under Chapter 234, Section 28.
So even though you're a very capable defense attorney and you've decided for whatever reason you still want this juror, I have to say I can't give you this juror.
Well, certainly Mr. Lease was not a very capable
I understand
defense
that.
lawyer.
And then you get into the strange part, you could say, well, you were ineffective for doing so, but then it's hard to say that the defendant can't claim ineffective assistance of counsel when the defendant waives his right to counsel. So that's the strange part of this sequence, is that we can't say he was ineffective because he waived his right to counsel.
Well, and again, I think we would be in a different position vis-a-vis waiver if this hadn't been raised within the appropriate time to do so, within the policy and spirit of the raise and waive rule, and before the jury was sworn.
Okay. Thank you, Ms. Campbell.
Thank you.
Ms. Campbell.
Good morning. May it please the court, Julianne Campbell on behalf of the Commonwealth. I'm here today asking that this court affirm the defendant's conviction for the brutal beating, death, and subsequent dismemberment of his father, Edward Lee. If I could just briefly address sort of the issue between the peremptory challenge or whether this was for a cause challenge and why it matters. I would begin with the peremptory challenge, and I'd urge this court to consider the defendant's attempt to strike the juror in seat 2 as a peremptory challenge, because that attempt to strike the juror was preserved error. This court should review for an abuse of discretion at that point as to whether the judge committed error in declining to strike that juror based on the defendant's peremptory. However, it is the Commonwealth's position that any claim that this was a strike for cause is waived. And then the standard of review this court should apply is whether there's a substantial likelihood of miscarriage of justice. But again, if I could focus first on the issue of whether or not this was a peremptory challenge, I would suggest that it most certainly was. And the record supports that interpretation. The first thing that I would point to is that when the defendant, 11 jurors later, after the juror is seated, attempts to strike the juror, he asks permission to do so. He asks the court, if you would let me do this one time, I would like to strike this juror. And I'd suggest that that's significant because a for-cause challenge can certainly be raised at any point during trial, and a party would not need to ask permission to raise a challenge for cause. He would bring it to the attention of the court, and the court would make a determination at that point. So in and of itself, I'd suggest that that's the first instance that supports the reading that this was, in fact, a peremptory challenge. The second point that I would highlight for this court is that absolutely, I think except for one, every single challenge that the defendant raised, he simply stated, I challenge this juror, I strike this juror. The court most often subsequently inquired a peremptory, and the defendant would say yes, or the court would say, okay, that's your 5th peremptory, that's your 6th peremptory. I believe only one time did the defendant explicitly use the word peremptory, and even more so than that, I would highlight that by my review of the record, only twice did the defendant explicitly challenge any jurors for cause. And when he did so, he stated, I challenge the juror for cause, and he offered the reasoning behind that. The first instance was on volume 1, page 100, when he highlights the residency issue of the juror who is being inquired of. And the defendant first states, I'd like to challenge the juror for cause. The court declines to do so because of where the juror lived at the time the subpoena went out, and the defendant then says he would like to use a peremptory. The second instance where the defendant asked that a juror be excused for cause was on volume 2, page 56. And there, I believe he raised a challenge for cause based on concern about the juror's ability to understand the English language. And again, that's just based on my review of the record, but those were the 2 instances that I saw where he explicitly challenged a juror for cause. So in contrast, where his consistent language for the use of peremptories was simply, I move to challenge, I move to strike, these sort of general terms that were construed to be peremptories, it is consistent that his delayed challenge would also have been construed to be a peremptory by the judge, and as this court should also consider. The third thing that I would highlight is that the defendant's failure, and this ties into the last thing that I mentioned, but the defendant's failure to raise this as an issue for cause. That certainly would have been an appropriate time to do so, in which case the judge could have further inquired of the juror who was still seated. They were still on day 1 of impanelment. And this was not a judge that was shying away from inquiring of these jurors. That first day, he did routinely use the same questioning, and on occasion, some jurors did express that they couldn't get past the graphic photos, and he would sua sponte excuse them.
There was no sort of preliminary questioning of the whole veneer to get on this question?
I don't believe of the graphic photos. I don't believe so.
There was not, okay.
I believe that was done during individual voir dire.
Can I ask another question?
Sure.
The judge here seems surprised that Mr. Lees is content. You know, he goes, you were content, with a question mark. Does he do that on anybody else?
He further clarifies a number of things with Mr. Lees, and I think that that's in an effort to sort of make an attempt at clarifying the record. I'm not particularly sure. I can't point to a specific instance with respect to the jurors. I'm sure that there are some, because I did note that.
What do you make, though? So Ms. Broadbent goes, the Commonwealth's content. The judge doesn't say anything. Then Mr. Lees goes, I am content with this juror, and the judge asks a question. It just seems he seems a little surprised that Mr. Lees is content too, right?
Again, I don't necessarily think that it's surprise so much as clarification, and I would point to the other exercises of the defendant's peremptory challenges, and I can certainly provide the court with cites if you'd like to all of those. However, in those, again, where the defendant uses a blanket language, the court routinely attempts to further clarify a peremptory challenge. You know, you realize that's your 6th, 7th, 8th, whatever. There are numerous times throughout the entire record where the court is attempting to clarify what it is that Mr. Lees is trying to ask the court to do. That's all that I attribute that exchange to be. But I do think it's worth noting, and I'll certainly get there, but with respect to the for cause argument that he twice affirmed he was content with the juror.
Yeah, what if we can't tell whether it's for cause or peremptory?
So again, I think that given that ambiguity and given the consistency in the record where he has been, the language he uses to express peremptory challenges, where this is an ambiguity, it's one of the defendant's own creation. He failed to create a record that is establishing that he was challenging this juror for cause. He failed to do that in an adequate manner. And I'd also suggest to this court that the assertion the defendant's now trying to claim is essentially asking this court to assume that where he failed to make a clear record as to whether or not this was a strike for cause, the experienced trial judge who we vest discretion also committed an error by refusing to inquire of a potentially biased or partial juror, that the experienced prosecutor, who is now a trial judge, was acting unethically by assenting to have a biased juror seated on this jury, and that all of the checks and balances that are in place during this impanelment process, not only the challenges for cause that can be raised at any point in time, but also the use of peremptories, that all of those failed. And he's asking this court to do this on a cold record that is, quite frankly, a bit ambiguous. And he's asking for a windfall from that, from this court. So I think that there is a strong record to conclude that this was a peremptory challenge, and quite frankly, it was not timely raised. The court outlined the procedure for raising. The defendant clearly...
Now, where was that done?
I'm sorry?
Where was that done? On day one?
If I could just have one moment. Page 74 of Volume 1 is at least one instance where the judge explicitly states you will have to exercise your peremptory challenge on the spot. If we don't want a juror after we've done the interview, you have to declare yourself. I believe he also did it one other time prior to impanelment on that first day. But again, I'd suggest that the defendant demonstrated that he knew the process by which to challenge jurors for cause or for peremptory challenge, because on page 100 to page 101 of Volume 1, he did attempt to strike a juror for cause. The court declined to do so, and then he explicitly exercised a peremptory challenge. He also, in between the seating of this juror in seat 2 and when he subsequently tried to strike the juror, there were about 11 jurors by my count in between. One of those, the defendant exercised a peremptory challenge on the spot. So I do think that the record demonstrates he understood the process and simply failed to timely exercise it in this instance.
But why would he move for a peremptory challenge if it would be more properly a challenge for cause if he knew the process?
Your Honor, I frankly, I wouldn't want to speculate as to what his reasoning was or was not, but
I mean, wouldn't it be fair to infer that he wanted to get rid of somebody who wouldn't be able to be fair, and somebody who wouldn't be able to be fair would be obviously well challenged for cause, right?
certainly, Your Honor, but at no point in this record is there any indication that he expressed any desire to strike this juror for cause. And frankly, I think that addressing the issue 11 jurors later simply is indicative of having second thoughts, as evidenced by the fact that he explained he misunderstood. It's difficult to try and assess what the mind of this person was, and I'd suggest that that's not what this court should do. This defendant did not preserve any challenge for cause. At no point did he make a record to support his claim now that that was a challenge for cause. If I could just briefly turn to my sister's highlighting of the Commonwealth raised this concern about the judge inadequately addressing bias. That was raised specifically on page 123. It was after this juror had been seated. It was after this inquiry, and it was immediately after inquiry of a juror who had indicated he had enrolled in the Boston Police Academy. It had nothing to do with the graphic photos that prompted that response, and I do think that that's significant. I also think it's significant that, and I advanced this articulation in my brief, but I'd suggest that the way the question is worded is certainly poor. I think it is a fair reading that in context, where we vest this discretion in our trial judge to pick up on how a juror is responding. Perhaps a juror is nodding along as a judge is asking a question. Perhaps, as this court has noted, when my sister was arguing, the intonation of the voice, this judge, despite this specific answer, no concerns were raised to him. No concerns were raised to the Commonwealth, and at the time, no concerns were raised by the defendant. And I would highlight that at least 14 other times during this specific day of impanelment, the judge asked the exact same question and either sua sponte excused a juror who clearly indicated they would be uncomfortable, or if the juror was not clear, the judge further inquired. And that happened several different times. Again, by my count, there was 14 times where the judge either sua sponte excused someone or further inquired of the juror that one day alone. So this was not a judge who was simply trying to rush through it. He gave consideration to how each of these jurors were responding. And I think that that's important that we vest that discretion in our trial judges who are there, who are actually assessing the parties' reactions, the jurors' reactions, and the answers, how they are said, how the juror appears. Whereas this court is merely left with the cold record and trying to delve into the mindset of what the answers, the questions, and the parties' responses may have been at that point in time.
No, I mean, we have a record in which he said, "Can you be fair and impartial?" And the answer was no. I mean, hopefully we can get a tape recording and attempt to evaluate whether the no was a hum or whether
Certainly.
the no was a no. But what do? We have 33E obligations too. We have a juror who says, "I can't be fair."
But
Is that, apart from issues of whether or not it was a strike for cause or a peremptory and the judge's desire to maintain his protocol that you have to decide on the spot, what do we do with regard to 33E?
well, I think it ties into, I think that ties into my waiver argument, but I respectfully would disagree with the court's assertion of what that specific exchange with the juror was, because it wasn't, can you be fair and impartial despite the photos, and the answer was no. The specific question is, the judge framed it, I believe, as the question is whether these graphic photos could affect your ability to be fair and impartial, and the answer was yes. And I think that it is a fair reading, given context, that it could simply be an assertion of, yes, I understand that that's the question at issue, not, yes, in fact, those graphic photos will render me incapable of doing my job as being fair and impartial. And I think that's further supported by the fact that the judge goes on to ask, well, do you have any other concerns about your ability to be fair and impartial? Can you help us through this trial? And the juror says yes. Given the way this...
Says no, sir.
I apologize, but that he has no other concerns.
But that's the other part that I'm perplexed about. I must say, all of this particular voir dire perplexes me, because the judge says, do you have any other concerns? Which bespeaks that this juror did have a concern about his ability to be fair and impartial. Otherwise, there's no reason to use the term other. So there is reason to think that the judge understood that the answer was yes and still moved on.
Your Honor, at best, I do think that it is ambiguous, but I would urge this court
What's ambiguous? I mean, without a tape recording, it's not ambiguous. Maybe if you give us a tape recording and we can hear the yes, maybe we can determine that it's, but on this record,
Well,
it's not ambiguous on this record.
I'd suggest that in the context of the entirety of this voir dire, it is ambiguous.
Not
because
much in the voir dire for this particular juror. I would feel better if it was a more comprehensive voir dire, but the whole voir dire is really two questions.
But certainly, Your Honor, even if
Three.
even if there were potential concerns about this juror's ability to remain fair and impartial despite the photos, that is a claim that has been waived by the defendant. And it's been waived because he twice assented to having this juror seated by telling the judge, yes, I want the juror seated, essentially. And then he simply did not raise a timely objection by waiting 11 jurors later.
Let's assume it's waived. Let's assume it's waived. In the public trial world, when we say it's waived, we then look to see whether there's a substantial likelihood of miscarriage of justice, and there basically never is, or nearly never is. But this is not whether or not your trial rights are affected by the fact that only the prospective jurors were present during jury selection. This is that you have a juror, sitting juror, deliberating juror, who has raised concerns about his ability to be fair and impartial in light of the graphic photos. That's a harder substantial likelihood analysis. So help me to see how we should do that.
Well, I think that in this case, there simply is not a substantial likelihood of miscarriage of justice, given the overwhelming evidence against the defendant, given that there essentially was not a very real defense other than challenging the identity of the victim. And furthermore, I'd suggest that this judge repeatedly urged the jurors to not use those photos in an improper way to evoke sympathy or bias and to decide or be persuaded by that. He repeatedly urged the jurors and cautioned them to not do that. And on top of that, this is not a situation where that was exploited. The prosecutor did not hold up the photos and parade them around and try and evoke sympathy during closing. She merely said, use these photos to the extent that you can understand the beating that this victim endured that caused his death. Given these facts, there simply cannot be a substantial likelihood of miscarriage of justice where the evidence was so overwhelming, the prosecutor was properly restrained in her use of the photos, and the judge repeatedly cautioned the jury to not improperly use those photos. So, unless this court has further questions on the issue of cause, I respectfully ask this court to decline to exercise its powers under 33E, and I am asking you to affirm the defendant's conviction for murder.
All right, thank you.
Thank you.